Darrell Brooks Jr., 21 CF 4596, 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good morning, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor. Injury clothing. Good morning.
All right, good morning, everybody. Hi, Mr. Brooks.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin State Prison System. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates the amended information's not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent as to, he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right, and the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right, all right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. So that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no
2
contest.
charges. See, I told you I would do it.
I know you did.
It is habit, I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. So You've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the two, or sorry, did it again, no contest plea to the two, and then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read-in charges, and I can take those into consideration when I sentence you on the two that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the two that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years is broken down into two parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count one felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
Do you also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole?
Yes, Your Honor.
Do you further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty, and at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes? Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second-degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right. And in 21 CF 5020, felony intimidation of a victim?
No contest, Your Honor.
All right. Now, I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged? Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
Do you also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second-degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct? That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
All right. As to count 1 in 21 CF 5020, do you understand, that's the felony intimidation of a victim, that if we had a trial in that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as to the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions, or are you confused about anything we're doing here today?
No, Your Honor.
Are you pleading no contest because, again, you understand the state has adequate evidence upon which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor, and to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so he would have them. The witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right, the court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
All right. Mr. Brooks, you said that you read and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there is a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense of second-degree recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
No.
All right. And is,
I'm not moving for remand. I normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscobel, I'm not asking for remand.
right, I agree with that.
Correct.
Generally, I would remand someone, given the seriousness of the charges that you just entered into and that what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome. All right, so I have some warnings for you. You may not have any firearms as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in place at least until after sentencing. All right, we will select a sentencing date, and I will see you then.
Thank you, Your Honor.
You're welcome.
Parties available August 9th at 9 o'clock.
No. That week, I can do any of Monday, Tuesday, or the Wednesday, not the Thursday or Friday.
That week is not good for this court.
Okay.
Okay. Then the following week is a good week for me, except for Monday,
Okay.
generally.
August 16th, 9 o'clock.
That'll work.
That
Works
works?
for the state.
Yes.
Next court date will be August 16th at 9 o'clock for sentencing.
Friday, August 16th.